what happens to kids who do turn 21 after you do the math under the Child Status Protection Act? Fortunately, Congress thought of this, and they put in something that's called the automatic conversion clause, something that is very controversial, and we're actually litigating this in the federal courts right now. Let's take an example because, you know, sort of an example is worth 1,000 words here. Let's take Maria Garcia. Maria's aunt is a U.S. citizen, and she applies for the mom and Maria when Maria is 9 years old. But because the waiting times are so long, by the time that the mother gets a green card, Maria's already 22 years old. She tries to get a green card, but the Immigration Service puts her in deportation proceedings, and she argues that the automatic conversion clause saves her and she should get a green card under the Child Status Protection Act. That case is denied. It goes up to the Board of Immigration Appeals, and the Board of Immigration Appeals agrees with Maria that she is saved. And why is she saved? Because the automatic conversion clause says this. They say when the child ages out, despite, turns 21, despite doing the mathematical formula, that child is entitled to the original priority date. What's the original priority date? That's when the aunt applied for the mother and for Maria, which was many, many years ago, and gets to be put in the appropriate category. And what's the appropriate category? Well, Maria has no status. Her mother's a permanent resident of the United States, and Maria is now over 21. So the adult children, unmarried children of a permanent resident, are in the 2B category. So using the 2B category, using the old priority date, Maria is eligible to adjust immediately. And that's what we're arguing in federal court. The government does not agree with that. How can they not agree since the Board of Immigration Appeals already said that this is the law? Matter of Garcia is a non-precedent decision. It only applies to that one person, Maria Garcia. Back in 2009, the Board of Immigration Appeals did a 180-degree turn in Matter of Wang, and with a very similar case said, no, you know what? It does not apply to these derivative beneficiaries. It only applies to people that were in the 2A category, which is children of permanent residents, who now are over 21 and they're in the 2B category. I think they're misreading the law because it clearly cites to the section of law that has to do with derivative beneficiaries. But watch our website. We will be talking about this in the future. Now, one question that's been asked over and over again is, to what extent is the Child Status Protection Act retroactive? I mean, it was signed into law by the President on the 6th of August, 2002. Does it apply to people who had visa petitions filed before then, approved before then, or only after that date? Well, Section 8 of the law is the effective date of the Act, and it clearly says that people with pending petitions on that date are covered. People with pending applications for green cards are covered. And then it has another clause that says, if a visa petition was approved before the law passed, but there's been no final determination on an application for a green card, then those people are also covered. And here we're talking about tens or maybe hundreds of thousands of people who could benefit. Originally, the Immigration Service said, oh no, you have to have something pending. And then this went to the Board of Immigration Appeals, and in a precedent decision, which means it applies to everybody, matter of Avila Perez, the Board of Immigration Appeals said, no, there doesn't have to be a pending application for adjustment of status or for an immigrant visa as long as a visa petition was approved before 8602, or remember in the other clause, pending on that date. Even if you've never filed for adjustment of status or for an immigrant visa, it applies to you. So if you think that the Child Status Protection Act may aid you in keeping your family together, go see an experienced attorney who's expert on the law, and you may have your family remain intact.